Carl Blake is a partner and employment law expert at DLA Piper, and he's here to speak to me for this week's Toil and Trouble instalment about two very important developments in workplace law. Carl, thanks for coming in.
Pleasure, thank you.
Now let's talk about this new ACC decision, where bullying and harassment apparently have been accepted as a work-related mental injury. This seems like it would have many ramifications. Can you just outline the case for us, please?
Sure. So certainly for a number of years, workplace mental injuries have been a valid form of gaining ACC cover, bearing in mind that in a simple terms, if you break your leg at work, and ACC grants cover and it's a work accident, it's a nice simple process. Mental injury is more complex, of course. This case is interesting because it stems from incidents of bullying and harassment, which is the first I'm aware of that has been accepted as a workplace mental injury due to workplace bullying, which is a new avenue we've not seen before.
And you say that in this case the behaviours regarded as harassment and bullying are at the very low end of the scale.
Yes, and I certainly don't want to minimise the impact on the individual in this case, because there was clear medical evidence and a diagnosis of post-traumatic stress disorder and depression. But purely objectively looking at all the spectrum of cases that we've seen in the past about what constitutes bullying and harassment, it was at the lower end. And just by way of example, there were two incidents that she relied on. One was a restructure where she felt she was treated very poorly. And secondly, there was an issue where she wanted to take her work laptop home, but in front of others was denied that right and felt as though she was being victimised and not trusted to be able to take the laptop from the building. And those incidents, if you had just said, how does that split in the spectrum of poor behaviour? I'd say, well, that is probably quite upsetting. But in this circumstance, and for the relevant background, which we'll get to in a minute, that led to a very large breakdown and a diagnosis of post-traumatic stress. So the unusual factor here is that it's relevant to what the employee had brought to the table with their particular vulnerabilities that was relevant.
Can you just outline what those vulnerabilities were?
Well, so the relevant factors here behind the scenes were that this employee had worked coincidentally for ACC, but that's not relevant to the fact that she's getting ACC cover. She had moved from Whangarei to Christchurch to pursue what she called her dream job. And as part of that process, she uprooted her family, and that carried with it an inherent amount of stress. And the court found that when looking at someone who had been through that experience to move and uproot their family and bring to the table that background facts, the incidences that she complained of had more of a profound impact on her. And the difficulty I'm having with this decision is that the section of the Act which talks about is there cover, is there a workplace mental injury, has two factors. There must be an event, which she can demonstrate here. There were these two instances of events. But this, what I would call an objective test, the Act, and I'll just look at my notes here, it says the incident must be something that reasonably could be expected to cause mental injury to people generally. Now, I read that to be your average person. Would the average person react or be as affected as they were in this case? The court looked at that test and said the average person must be looked at on the basis of the average person with this person's history and this person's circumstances, which seems very objective to me and allows effectively a more vulnerable person to be given greater leeway, if you like, to be captured by this test.
Do you mean subjective in the last sentence?
Sorry, did I say yes? Certainly, sorry. Yes, it's introducing a subjective element to this, which even though the words people generally is a very broad term and it's unusual to see that in legislation, you can see exactly what they're trying to get at. It's an objective, common standard that I thought they'd be applying.
So this opens up a big can of worms from just from my lay person's view of it, and I'm interested to know what you think. I mean, if I'm an employer and I'm looking at someone who has to uproot their family to be in a new workplace with me, I might have pause for thought if that person it can call on that experience to change a judgment in their favour about harassment.
Well, exactly,
and
it's like you wouldn't necessarily know as an employer what someone's personal circumstances are, and I would have thought that this test is intended to remove that from the equation.
Yes.
I suppose the other way to look at this is that let's reflect on the impact for the employer. Here, there is no direct impact beyond potentially a PR impact because we've got no direct costs being incurred by the employer. It's simply an access to entitlements under ACC legislation that the employer doesn't control unless they're accredited employer and has to pay those costs themselves.
Yeah.
But it opens up an avenue over and above the avenues that a person already has to pursue a claim of bullying and harassment, which is personal grievance claims, of course, breach of contract for failing to provide a safe workplace, and potentially notifying WorkSafe if there are systemic issues of bullying in a workplace. So this adds another layer to that.
Yes. Is there not also the Whistleblowers Act that can look at these as well?
That's actually a very good point, because you see the recent developments in that legislation open up the safety of a person as the potential grounds for raising a disclosure for serious wrongdoing. And we've got concerns that that is yet a further way of blurring the lines between where you should be pursuing these complaints. Again, no attempt to minimise employees' rights and abilities to pursue these claims, which can be entirely valid, but there are already mechanisms and jurisdictions in place to deal with those.
The cost to the employer would have been moving this person to the new city, setting them up, and losing them because they've gone off with this claim. Does it mean the person doesn't return to work and is on ACC for the foreseeable?
Yes, I couldn't tell you what happened after the claim was accepted, but yes, looking at some of the facts of the case and the profound impact that these actions had on the employee, certainly in the short term from when this decision came out, there was a significant period away from work. I don't know if what happened after that, but she was referring in this decision to the actions of the employer being so significant as to constitute a constructive dismissal.
Wow.
So it may well be that the employment ended, but I'd be speculating on that.
It would be difficult to go back, whatever
correct.
the case. Now let's talk about a different issue, which is also sexual harassment. But there's a bill before Parliament at the moment to extend the time available to raise a personal grievance that involves allegations of sexual harassment from 3 months to a year. Why is this being considered?
Yeah, so it's an interesting point. The statistics tell us, certainly the investigations from the government, that it can take more than the typical 90-day period for raising a personal grievance for a victim of sexual harassment to get their head around it and to decide what's happened and whether they should be pursuing some form of claim. And the bill is intended to allow a greater period than the current period of 90 days to properly allow someone to process what's happened and pursue a complaint if they wish. At the moment, all types of personal grievances are capped effectively to a 90-day period from when the incident occurred or when it came to their attention. This seeks to extend claims involving sexual harassment to 12 months. A couple of issues arise there. Of course, that certainly makes a lot of sense that for this type of behaviour there may be more to process. It could create confusion for employers potentially, where the personal grievance involves more than sexual harassment, because this talks about personal grievances involving sexual harassment having a period extended. Well, what if it involves something else and sexual harassment? Does that mean all of the issues can now be waiting till 12 months? And also it just potentially gives rise to some lack of clarity, particularly after employment's ended. Some employers, if the employment didn't end well, will effectively start the clock ticking for 90 days to see whether a claim comes in or not. And logically, once that 3-month period is up, they can more easily move on and be comforted that there won't be a claim. That would now extend to 12 months. So it's not a direct burden on the employer, but it's just something they'll need to bear in mind and factor in with any ending of an employment relationship.
Given the way these issues are sort of moving, the general trend, do you think it's likely that this will pass, will go through?
Well, it's not receiving a great deal of press. I couldn't speculate as to how much support it has, but certainly the intent behind it is, I can see that. I can see the merits and I can see the benefits. And given the relatively low impact on employers, it's not something that would be, I don't think, vehemently opposed.
Taken in a totality, do you think, from your experience in the employment court and other authorities, that victims of harassment and bullying are getting more of a fair deal? Are they getting too fair a deal? Like, can you give any kind of indication of how the courts are looking at these
It's
things?
such a vexed question depending on which side of the spectrum you sit. Some advocates and commentators say that our system is completely flawed and unable to deal with bullying and harassment and sexual harassment. I disagree. I think between the Human Rights Commission and the employment jurisdictions, there are many avenues to pursue complaints and have them properly heard. This simply wouldn't change the way that happens. It's simply the time frame for doing so.
Right. So if employers, though, feel like, more and more, every authority is going to take the employee's side come what may, that's not quite accurate?
No, there is some perception that, particularly in the Employment Relations Authority, it is employee friendly. And there are some examples that you could easily point to where it looks as though the employer has had a raw deal. The Employment Court is typically, and particularly the Court of Appeal, far more based on the black letter of the law. But still, depending on which side of the fence you are, you feel that maybe a decision didn't go quite the way it should have. I don't see a trend towards that. I think there has always been a reasonable element of employees getting a fair deal where appropriate. And employment law is so heavily based on good faith and reasonableness that it makes sense that if someone's been wronged, typically the law will support that. Not every time, but that's where its fundamentals are. And if that means that an employee that's been treated unfairly has their day in court and succeeds, well, that is the system working.
Carl, thank you very much for coming in.
Pleasure, thank you.